Florida Governor Ron DeSantis is readily accumulating a bunch of my mans from Republicans all across this country. He keeps doing the things Republicans want to see done. He keeps going after the people and the companies that Republicans want to see challenged, and he keeps taking to task politicians and policies that Republicans don't like. The man is making a strong bid for President of the United States in 2024, and he seems to be laying the groundwork for that. But we, as a country, may need to pry him from Florida's cold, dead hands, because they may really want to hang on to him as governor. His latest move is to put on notice big tech companies like Facebook, Twitter, YouTube, and other social media giants for this idea of deplatforming, and specifically in regards to elections. I think the election of Donald Trump, or the 2020 election involving Donald Trump and Joe Biden, and Donald Trump's removal from the platforms has politicians finally looking at deplatforming as something that actually threatens their power, that actually threatens their ability to get their messaging out, and messes with, maybe inappropriately, the election process of the United States. Let's talk about what he's doing and what I think about it, and if this law has any chance of sticking around. These are all complicated questions. Make sure you watch through the end. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, hit the like button, hit the subscribe button, turn on your notifications so you don't miss any videos. You want to make sure you see whenever one of these things pops up so you know what's going on, and know that I appreciate each and every one of you. Thank you so much for always making this a fun thing to do and helping the channel grow as well so we can talk about these issues. Now I'm done blathering about me. Let's talk about Ron DeSantis and this new law. All right. Florida governor signs ban on deplatforming by tech companies. And that article headline is a little bit broad, but it is more clarified here. The law imposes penalties of up to $250,000 a day on a social media platform that bans a candidate for office. The tech industry says the law takes us closer to a state-run internet. As if we're not already basically there. Like, listen, when the tech industry is acting as the propaganda arm of a particular political party, I don't think they have much grounds to say that we're taking us closer to a state-run internet. And this doesn't do anything of the sort. In fact, this very much keeps the lines of communication between the politicians and the people open for the people to then make the decision, rather than having big tech acting as in fiat for a particular political party, having those discussions made for the people. But let's check out the article here. It'll be linked down below if you want to watch it or read it, I guess, on your own. You can do so. You see a lurking James O'Keefe by Project Veritas over there in the side of the picture, and Ron DeSantis is surrounded by a bunch of very serious looking people. Very serious. They look, except for the one guy who's kind of smirking. Here we go. Florida Governor Ron DeSantis on Monday signed a law that gives the states the power to penalize social media companies when they ban political candidates, escalating a fight between the tech industry and Republicans such as DeSantis and former President Donald Trump. The law to prohibit deplatforming is the first of its kind in the nation and may be a model for other states to follow, even though one tech business group said the law runs counter to the First Amendment. And of course, that is the first reaction to most people who see this law. Well, you can't stop big tech. You can't force them to host speech, and you can't force them to allow people on their platforms. But actually, that's not true. That's not true. As Justice Clarence Thomas has laid out, there are avenues for challenging the ability of big tech to go ahead and just do whatever they want on the platform. We have given them immunity from various lawsuits. We have protected them from claims. We've given them infrastructure to work with. And some of those things may come with a caveat to treat people equally, regardless of their political positions, regardless of their party affiliations. And we've seen this in history, things like telephone companies, telegram companies, other communication providers have something called like a common carrier status. And not all of them are the same, but it's akin to this idea of conveying information from point A to point B should be neutral. And these platforms shouldn't necessarily have the ability to censor that content, and more appropriately, to remove people from access to the ability to communicate by that service. Now, no one says that a company should be forced to host specific content on their platform. And let's be very clear, they're not. And no one, including this law, is suggesting that these companies can't have terms of service for inappropriate types of content that they won't support, violence, pornography, other things like that. No one's forcing them to use their platform for these services. However, these companies have long held, for many years now, the power to review every single thing that comes down. There's no reason to deplatform anybody from using the platform when the platform controls with an iron fist what is actually allowed to show up on the service. You can't tell me that Twitter, who can tell if I'm being too mean to someone before my tweet even goes up, is unable to determine if there's threats of violence or other activities that break, their terms of service, the abusive use of slurs or other things like that. Those are things that are already being detected by these systems, by these companies in real time. To suggest that they can't do that and must instead resort to removing people from a platform forever is a bit more than just being forced to allow certain speech on their platforms. DeSantis celebrated the law as a blow against Silicon Valley elites who he said were seeking to censor conservative political views. And that may be true. That may be true. I don't know if that's actually their motivation. It's certainly how it seems to be manifesting these days. But the reality is they want power. They want the power. I don't know that they're as partisan as they seem, because they want the ability to choose whichever one they want, right? Like if they want to control in favor of Democrats, they can do that. They want to be able to also control in favor of Republicans if it should ever become useful to the company. And of course, companies want control over public opinion. They want control over political things. They want to ensure the existence and survival of their company and the profitability for their shareholders. That's how they operate. It's not necessarily nefarious, but that doesn't mean that the influence that they wield is properly done. Now, of course, there's a bunch of industry pushback on this. The platforms themselves have not responded, but what we've got going on is the industry saying this is counter to the First Amendment, this is against our rights, and you shouldn't force us to do this stuff. I ranted about that already, so we're not going to go too much more into it. But at the end of the day, the big question is this: will this law pass constitutional muster? And at first glance, it's easy to say no. This is a toothless, unenforceable law. It'll be struck down the moment it's challenged. At first glance. But there are real legal questions here. So let's briefly discuss how these things work. At a very high level, I'm not going to get into the super detailed weeds on this because it would take, pages and pages and pages. And those pages are going to be written about this law, because this law will be challenged, it will go to court, and those arguments are going to be made by competent legal representation for Florida and for the big tech companies. You can expect some of the best in the business will be arguing about this. But let's take a high-level look. So when you're implicating issues of free speech, and that's what this is, you're typically going to be looking at something called strict scrutiny, which is the constitutional sort of lens that the Supreme Court uses to determine whether or not this is too restrictive of a right. And this is typically encountered when you're triggering a fundamental right that is laid out in the Constitution, like speech. It's very clear, it's very robust on what kind of speech we have. And this is directly political speech, right? This is related to political candidates. So it's the highest level of protection. We want to make sure the government is not unduly influencing speech. So to pass strict scrutiny, to uphold this law, it has to, one, further a compelling government interest, not just a legitimate government interest, not a rational government interest, but one that's compelling, one that the government has a need to do, its purpose, its core thing. And in this case, I think the argument would be that it's ensuring fair elections, free and fair elections. And we've seen stuff like this survive constitutional muster before with the Fairness Doctrine. The Fairness Doctrine was the idea that you couldn't have one party dominating radio waves. So you had to have equal time given to equal broadcast hours given to both parties. This is something that was around for a while. It's no longer really there, but it's why some shows, some radio shows for Democrats even existed, because the conservative side of the spectrum was dominating radio waves for so long. And we've kind of returned to that. Guys like Rush Limbaugh and Sean Hannity and Glenn Beck, really had a stranglehold on broadcast hours and broadcast attention. They were getting better ratings. But that being said, we've had doctrines similar to this before, not necessarily in the terms of political candidates, but in open access to communication that does not discriminate between left and right, or specifically doesn't allow the broadcaster to discriminate between left and right, is maybe a better way to look at it. Now, of course, these are not linear comparisons, and the Fairness Doctrine is not really implemented right now at all, which is why Hollywood is terrible. But that being said, and I'm not advocating for the Fairness Doctrine either. This is the idea that you don't have political discrimination in who gets to communicate in regards to elections on a particular platform. And that is maybe a compelling government interest, the ensuring open communication and broad access for people, no matter their party affiliation. And I think really some of the smaller parties need to be looking at this as well. This is not just a Republican-Democrat issue. You've got libertarians, green parties, you've got other, the cannabis movements and stuff like that have formed political parties that may not be allowed platforms based on their views. This would prevent that for them as well, ostensibly. So once you've determined that it furthers a compelling government interest, it has to be the least restrictive means possible to further that government interest. So it has to not sweep up otherwise constitutionally protected activity in its goal of protecting or I guess regulating this other piece of information, right? So if they're gonna force platforms to host left and right people at the high level here, are they preventing? Are they sweeping up other constitutionally protected activity? And I think this law looks like it's written with this in mind, to try and narrowly tailor the regulation to only say, look, you only can't ban a political candidate for office. It doesn't say you can't ban a politician who's in office. It doesn't say, and specifically, it allows them to suspend them for up to 14 days, and it allows them to have messages still comply with their terms of service. So they don't have to deliver any specific communications. If someone's out there violating the terms, they don't have to deliver that content. They just can't ban the candidate from the platform entirely. So this looks to be very narrowly tailored. Is it narrowly tailored enough? That will be the big question here, and we don't really have anything to directly compare this to that I'm aware of. It may be out there, but I don't think so. Social media is new enough. Social media censorship is even newer in regards to the scale and scope and the political nature of it that we've really been seeing. And so this is a new test case, test law, and we'll see what happens with it. This got longer than I expected, but I wanted to make sure and talk about whether or not it would withstand constitutional muster. It's easy to say no, but the sort of themes in this law point to a possibility that it might. is it narrow enough? We allow restrictions and impediments on protections so long as they fall within the scrutiny level that the court applies to this. This is going to be strict scrutiny, and usually the government loses on strict scrutiny, but this time we'll have to see, because they seem to have written it in a way that comports or attempts to comport with that concept. But what do you guys think about this? Should the government even be doing this? Should they be telling big tech who they can and can't have on the platform? And if they do, should the Supreme Court uphold this or get rid of it? I'd love to hear your thoughts. Drop them in the comments below. We'll see you next time. Peace. Peace.